Hello everyone. Even though tonight is technically the last day of August rather than the first week of September when we usually do our updates, but we thought with so much happening this month in US immigration, it would be better to do our update a little early. So what are we going to talk about? Honestly, with so much going on this month, it would almost be better to say what aren't we talking about? This administration and USCIS are keeping everyone in the immigration field on a roller coaster ride. Today, we're going to discuss the on-again, off-again firing of USCIS employees, USCIS fees increasing, that will be happening. 3, DACA. USCIS isn't doing what the Supreme Court told them to do. Public charge. First, it wasn't going to be enforced, and now it is. New asylum processes and work authorization application changes. And that's not all. Most importantly, we're going to explain how each one of these things will impact you and your immigration journey. Welcome to our show.
Calificas para ser legal, quieres saber, solo llama al abogado Andrés Mejer.
Let's move on to new asylum work authorization procedures. I talked about this in my video last week. Some things about asylum are changing. This change went into effect on August 25th, 2020. Anyone who applies for asylum today or in the future cannot apply for work authorization until 365 days after their application is received by USCIS. Let's break this down. When you send your application to USCIS, you receive a receipt notice. I call it a thank you for your payment notice, but you get the idea. On that receipt, you will see an A number that has your receipt date. It's a 9 numbers and it starts with an A. For example, A123-456-789. That receipt has a receipt date. That is the official date when USCIS received your paperwork. According to this new policy that again went into effect just last week, you can't apply for work authorization until immigration has had your case for 365 days or 1 year. At this time, it's taking 3 to 6 months for employment to be approved, employment authorization cards. Imagine what it's going to be like in 1 year with USCIS slowing down because of cutting operational expenses. How much longer will it take? So you're an asylum seeker who probably came to the US with very little, and now you are not only legally not able to work, you can't even apply for over a year. And practically, we're really talking about 1.5 to 2 years from when you entered or when you applied. This seems like yet another way for this administration to stop asylum and immigration without having to follow the law and procedures. Guess what, guys? Public charge is back. Remember how I talked about the new public charge policy? Again, I'll put a link in the comments to this video. We went into great detail for this rule because it is truly a game changer, and it is designed to allow immigration to deny more applications. Public charge refers to looking at the finances of a person applying for immigration benefits and says, are they likely to need government assistance? If so, they will be denied. This goes along with this administration's desire to move to a merit-based immigration-only policy. At the beginning of the pandemic, USCIS said they would not apply the public charge review to any applications during the pandemic. While this was happening, lawsuits against the public charge were going through the courts. One of those courts was in New York. On July 29, 2020, a judge in New York granted a nationwide injunction. That means stopped completely USCIS from implementing the public charge rule for the entire country during any period when there was a public health emergency. On August 12, 2020, the Second Circuit Court of Appeals, a higher court, limited the injunction to only the Second Circuit, meaning it only applies to people who live in Vermont, Connecticut, and New York. If you are outside the US applying, you are not subject to the public charge because of that preliminary injunction, which was issued at the same time as the one for the Second Circuit for those 3 states. So what this means is that if you are applying within the US and you are not in Vermont, Connecticut, or New York, and we are in New Jersey, then you are subject to the public charge and you need to file Form I-944. Nice and complicated. It's only about 20 pages. New employment authorization application and policy. When you apply for employment authorization, you file the Form I-765. As of August 25th, 2020, you must use the new form when you file. Make sure the new date has 8/25/2020. It's on the bottom of the application when you submit it. What this new form and policy does is make it harder for you to be approved for employment authorization. One of the most important changes is question 30B. It asks if you entered the US lawfully. You're also required to provide evidence of this lawful entry. If you did not enter the US legally, you must say you did not, and you must explain why you did not. We highly recommend that if you did not enter the US legally, either as a child or an adult, that you meet with an immigration attorney before answering these questions. Remember, DHS shares any information submitted to them with all agencies, including ICE. I would hate to see an answer on an employment authorization form cause you to wind up in deportation proceedings. With all of this seemingly bad news, we'd like to end on a few bright notes. On August 25th, 2020, the Department of State said that embassies could expand the ability of consular officers to waive in-person immigrant visas until December 31st, 2020. It means they may not require you to come in person for an interview. Previously, they could only extend these waivers to someone whose visas expired within 12 months, but now it's being expanded to 24 months. This is good news and might help speed up the process for those waiting for an interview to enter the United States. Lawsuits were filed against USCIS due to the printing issue for green cards and employment authorizations that we mentioned before today and also in the prior video. On August 21st, 2020, the U.S. District Court in Ohio issued an injunction telling the government they had to issue work permits within 7 days for those who had been approved and not yet received it. Also, USCIS agreed to post a notice on their website stating that if a person has not yet received an employment authorization card but has received a notice that they were approved, that notice can be considered as work authorization, even though the notice itself says it can't be. I know, nice and confusing, isn't it? Thank you for watching. Remember to like our Facebook page and choose to be notified whenever there is breaking immigration news. If you're watching on YouTube, please hit the thumbs up and subscribe buttons. And if you found value in this video, please share it with your friends and loved ones that might want to learn more about immigration. You can always message us on our Facebook page or email us at info@andresmejerlaw.com to discuss your case further. Well, see you next week. Stay healthy and be well.